Good evening. I'd like to call the meeting to order. Welcome to the June 28th, 2022 meeting of the Oxford, Ohio Board of Zoning Appeals. Mr. Moore, would you do a roll call on board members?
Yes, I will. I'll start with Mr. Conrad.
Yes.
Ms. Rumanier.
Yep, I'm here.
Mr. Allison. Here. And Mr. Schnipper.
Here. Let the record show that all members except Mr. Ames are present. Mr. Ames was previously excused. Quick question for you, Mr. Moore, before we begin. Was the applicant aware that we may not have a full board prior to the meeting?
Yes, they were made aware.
Thank you, sir. First order of business is approval of the April 26, 2022 minutes. Kate, you're going to have to abstain from this one since you were not present. Cal, Chris, any additions, deletions, or corrections?
No.
I've got one correction in the transcript. It is on page 5, first full paragraph on there, 1435.3. That's attributed to me, and actually was Sam Perry that was speaking at that time, so if you can make that change. Any other changes, Chris, Cal?
No.
Is there a motion to adopt the minutes as amended?
So moved.
Thank you, sir.
Second.
Thank you. All in favor say aye.
Aye.
All opposed? Without opposition, the minutes are approved. We have one case to hear tonight, BZA 2022-02 for 314 University Avenue, seeking a variance to minimum lot width for a three-family dwelling. I need a motion to enter into adjudication.
So moved.
Thank you, sir. Second. Thank you, sir. All in favor say aye.
Aye.
Without opposition, we are in adjudication. Mr. Moore, would you please identify yourself and state your job title for the record?
Yes, Zachary Moore, City Planner for the City of Oxford, Ohio.
And raise your right hand for me. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in matters before the board?
I do.
Thank you, sir. Please proceed.
All right. Thank you, Mr. Chairman. Good evening, members of the board. So our first and only case of the night, this is BZA 2022-02. This is at 314 University Avenue, and a variance is sought to the minimum lot width in this case. Okay. The applicant for this request is Scott Webb Architect, who's with us tonight. The property owner is Calista Enterprises, LLC. The zoning classification for the property is R3MS, single, 2, and 3 family, mile square residential district. The current use of the property is a single family dwelling. The proposed use would be a 3-family dwelling. And the proposal is a request for a variance to section 1143.07C, minimum lot width to allow for 3-family. Here is a look at the location. So you can see the aerial imagery, and the subject property is highlighted with a black outline here. So here's University Avenue running north and south. East Sycamore Street is to the north. East Vine Street is to the south. And North Campus Avenue is to the west. Bishop Street is off the map, but it would be over this direction. And here's a look at that same extent, but showing the zoning classifications in the area, so you can see that the vast majority of the surrounding vicinity is zoned the same way, zoned R3MS. So this is a 3-family district.
I'm hearing feedback.
This is on, I think. This might be, I don't know how to turn it off.
Maybe you can put it on the ground on the step.
Hold on a second. This is push.
Well, it won't stay off if you have to hold it down.
Well, I can't, I don't think I can. Oh, you mean you have to hold it down physically?
Hold the button down.
Okay. Trying to move it out.
Still got it.
Is there a way to remove it? Or you just unplug it? Yeah, I know. Is there, I can't see that. Oh, I see.
I'll advance to the next slide. So this is a map showing some upzonings that occurred in the neighborhood. This is from 2017. So the subject property is noted as a white star. So you can see that this area was rezoned from R1MS, which is a single family district, up to a 3-family district. This is a 17-acre area here. And here are some site photos from June 17th. So this shows the existing single-family dwelling that sits on the lot. You can see that there's an existing driveway here, there's a carport. So the curb cut is off of University Avenue. There was some existing fencing at the time. It was a combination of a chain link and a privacy-style fence. That has since been changed. I'll show you a picture here in a moment. A vast majority of that has been removed at this point. And that is related to a concern that our fire chief had expressed when reviewing the application. These bottom pictures here are viewed from the alley that is behind the lot. So this surface right here, this is parking on the adjoining property to the north. And this grassy area here, this is the rear yard of the property. So here is a bird's eye view showing the single family home that's existing. It's outlined in yellow here. And then the same view. This slide shows a number of recent projects in the area, some of which would have predated the rezoning from R1MS to R3MS. Those are shown right here. So in 2014 and 2016, there were new single-family homes built on those particular lots. And then the blue shows new or converted 2-family projects. And these would have occurred after the rezoning. And the reason that they were possible was because of the rezoning from R1MS to R3MS. So the relevant zoning provision here, so this is extracted out of the zoning code. This is 114307C, provides the following minimum lot widths. For a single family dwelling, it's a minimum of 40 feet. For 2-family, it's a minimum of 50 feet. And for 3-family, it's a minimum of 60 feet. So the provision in question here with the variance request is for the 60-foot minimum for a 3-family. And the width of the lot in question is 56 feet. So the variance is for 4 feet. I will note also that in 2017, there were also some text amendments to the code in addition to the map amendment. So previously, in the R3MS district, the minimum lot width for single family was 50 feet, the minimum for 2-family was 75, and the minimum for 3-family was 90. So in addition to the map change, there was also a text change that allowed for greater intensity of use on smaller width lots. So going through the history here, this was a 2018 variance attempt. At the time, I believe there were a number of variances requested, one of which was the lot width, but there were a number of others as well. And this request was withdrawn prior to reaching the BZA, so there wasn't an actual decision rendered at that time on any of the requested variances. But this was the site plan that was shared at the time as part of the application. So when I flip to the next slide, this is a new site plan that was submitted in 2021. At that time, there were 2 variances requested. One was, of course, to the lot width. The other was for parking setbacks, to reduce from a 3-foot minimum setback to a 1-foot setback, to allow for 6 parking spaces to basically be paved in a row off of the alley. The staff report was released with the rest of the packet for, I believe it was the November 2021 meeting. And the staff recommendation at the time, staff had concluded that there was insubstantial evidence to support the request. So following the release of that report, we were notified that the application was being voluntarily withdrawn, so it did not reach this board in November of 2021 either. So the variance that is being considered here tonight, this is the site plan that goes with that. So as you can see, flipping back and forth between the November 2021 site plan and the current site plan, there are not many differences. The main difference would be the fact that they are no longer requesting a parking setback for the row of parking spaces off the alley. So they are providing for sufficient distance to meet the minimum 3-foot setback. And what they have done is stacked one of the parking spaces, which you are allowed to do by code. You're allowed to have one stacked space. And there would be a sidewalk or walkway leading from the parking to the entrances to the building and eventually up to the public sidewalk along University Avenue. So that is also an element that is unchanged between the submissions. So to describe the units that are proposed, so it is proposed as a 3-unit building. There would be a 2-story dwelling unit in the back, and the entrance would be facing outward toward the street, so certainly visible from the street. And we believe that this will meet the code's principal entrance provision, requiring a principal entrance to be upon the street. And in the front, up closest to University Avenue, there would be 2 stacked units. And the front doors to each of these units would be separate and distinct from one another. We don't have a floor plan at this time, but it's presumed that one of those 2 entrances would lead to a stair that would lead you to the 2nd floor into that particular unit. Of course, since the parking is being provided in the back, which is actually preferable per code to have parking off an alley when an alley is present, the existing curb cut would be removed and the driveway also would be removed to make way for this new structure. So the existing single-family home that was built in the 1960s, that would go away and be replaced with this new 3-unit building. Oh, and there's a slide that's highlighting the newly stacked space. And here is a slide showing you the degree of variation between the lot width for the existing lot, so that's 56 feet.
Does that mean 12 cars or 6 cars back here?
60 feet is the minimum lot width for a 3-family. So you can see the degree of gap here that's basically not there, and would have to be there in order to allow for a 3-family by right without requesting a variance. So this slide predated the removal of the fence. So at the time, it was noted that there were chain link and privacy fences in proximity to the structure. The minimum side yard setback in the R3MS district is 5 feet. So the applicant is showing an intent to meet that. So you can see this dashed line here that is noting a 5-foot setback. And when the fire chief had reviewed this proposal, he was concerned with the ability to put a ladder up against the side of the building in the event there were an emergency or a fire, that this fence would be an obstruction to that. So staff's view of that is there really wasn't a nexus between that particular issue and the issue at hand when it comes to the lot width. But nevertheless, since it was known at that point that that was a potential health and safety concern that was shared with the applicant, and since then, staff is aware that most of the fence has been taken down, and I'll show you here in a minute what that looks like. Yep, here it is. So this is a photo from the 27th of June. So you can see that the fence is largely removed at this point. There are a few posts that remain, but otherwise it looks like most of the obstruction has been, at least possible obstruction, has been eliminated at this point. Lastly, I will show you the renderings that have been submitted for past applications as well as the current application. So this is the 2018 variance attempt, and this is the rendering that was submitted at that time. So kind of a staggered approach to building the units. All the doors, of course, being visible from the street with this one. And then in 2021, this was an updated rendering. And it looks like this building could pretty well meet all of the mile square design standards. Certainly includes front porches, which is an element that we encourage for mile square development. And the rendering for the current request is the exact same as 2021. So this is the rendering that you should consider at this time. And it is for a two-story structure. So if the variance were granted by the board, then we would hold the applicant to building a structure that is following this rendering. Bless you. Okay, and I will go through the decision criteria now. But first, I will say that in accordance with section 1139.02C1, the burden of proof is upon the applicant to present reliable and substantial evidence that supports their request for variance. And furthermore, per section 1139.02C2, the BZA must find that practical difficulties exist that would render strict application of the code unreasonable. And in determining whether such difficulties exist, which are sufficient to warrant the variance, the board should use these decision criteria. So just to note on this slide, so a red X is noting something that staff believes does not lend support toward granting the variance. A yellowish orange question mark here is noting something where it's somewhat indecisive in terms of whether it's lending support or not, so we rate it as mixed evidence. We are also offered by the code criterion H, which is any other relevant factor, and we don't feel that there's any additional factors that are worth commenting on with this application, but the applicant can present additional evidence toward criterion H if they so choose. So I will start with criterion A. This is whether the property in question will yield reasonable return or whether there can be any beneficial use of the property without the variance. It is evident there is already beneficial use of the property since it is developed with a single family dwelling. The owner could also choose to redevelop the lot with either a brand new single family dwelling or a brand new two-family dwelling and meet all standards of the zoning code without necessitating approval of variances. Criterion B is whether the variance is substantial. So the applicant in this case is asking for a 6.7% reduction in lot width. This is to go from 60 feet to 56 feet. And staff believes the proposed lot width reduction is substantial, and this is consistent with the very first staff report that was composed for the 2018 variance request. Criterion C, we rate this as mixed evidence. This is whether the essential character of the neighborhood would be substantially altered or whether adjoining properties would suffer a substantial detriment as a result of the variance. So this particular block of University Avenue between East Sycamore and East Vine, as I had showed you in a previous slide, has experienced significant redevelopment in recent years. New single-family dwellings at 316 University and 317 University were constructed in the mid-2010s, and two duplexes at 313 University and 318 and 320 University were constructed recently. It is clear from the abundance of projects taking place on this block that viable redevelopment opportunities exist for one and two family residential uses without the need for requesting greater intensity of use as a three-family. It can be noted this property is located within an area of the mile square that was upzoned from R1MS to R3MS. I think the staff report notes it incorrectly. The prior slide with the map had shown R1. I think the staff report says R2. It should be R1MS to R3MS. This was done in 2017, and it was for the purpose of increasing allowable density in an area that's close to campus. However, there are numerous properties in the area which do meet the required lot width for a three-family. Turning to the proposed dwelling itself, the applicant's rendering does show a two-story dwelling, which is fairly consistent with the structures along the block, and thus would appear much more complementary to these other structures, despite the difference in the number of units that there may be. And I believe that the rendering that's been submitted in 2021 and the one that's currently under consideration is a much better design comparatively to the 2018 rendering. Criterion D, I believe that there is an update to this one in light of the change to the fence. So I would actually note this now as supporting the variance. The engineering department and the police department did not return comment on this. As I said, the fire chief had expressed some concerns with the proximity of the fence. I believe that issue has largely been satisfied. So I don't have any reason to believe that this criterion does not lend support toward granting the variance at this time. So you can consider D not a question mark, but a check mark now, which is what I normally put on the slide for those criteria that support the variance. Criterion E is whether the property owner purchased the property with knowledge of the zoning restriction. We find this does not support granting the variance. So the same variance for lot width was previously pursued in 2018 and in 2021, but withdrawn both times prior to reaching the BZA. According to the prior staff report, the property was purchased in 2000 by Ned Helzer, and at that time was zoned R2, which was a small lot, single-family zoning district. So therefore, the investment-backed expectation for the property was for a single-family when purchased. The property was rezoned to R1MS, looks like it says it correctly here. It was rezoned to R1MS as part of the 2003 code rewrite, and then was later upzoned to 2017, or excuse me, upzoned to R3MS in 2017. Criterion F is whether the property owner's predicament feasibly can be obviated through some method other than a variance. The original plat for this area has more or less predetermined the lot widths for the area, many of which do not provide sufficient distance to allow for the highest possible use per the presently zoned R3MS district. Still, there is already beneficial use of the property with a single-family dwelling, and it is also possible by right to densify this lot by raising the existing building and constructing a new two-family. So for these reasons, we do not believe a true predicament is posed by the current request. It is simply the desire for highest intensity of use. Criterion G, whether the spirit and intent behind the zoning requirement would be observed and substantial justice done by granting the variance. We find that the general purpose of minimum lot width regulations is to ensure regularity of dimensions and form for specific land uses or districts, resulting in a predictable ratio of building size to lot size. The purpose of regulating density also factors into the subject of minimum lot widths. So when it comes to 1, 2, and 3 family uses, the prescribed lot width regulations in the R3MS district, these are actually the smallest widths of all residential districts in Oxford, and thus result in the greatest degree of density that's possible for such uses along any particular stretch of block. For example, R1MS prescribes a 60-foot minimum lot width for single-family uses. In R2, the district prescribes a minimum of 50 feet for single-family, 75 feet for two-family. The R3MS standards are 40, 50, and 60 feet for single, 2, and 3-family uses, respectively. The text amendment was processed and adopted around the same time as the upzoning of the area from R1MS to R3MS. Thus, it is clear the intent was not to allow 3-family on every property just for the sake of increasing density. So the two were considered around the same time. So decreases in minimum lot widths and rezoning of property I actually just said that. They were considered at the same time. They were considered together as one package of amendments. Entertaining variation in the standards adopted in 2017 would thus mean entertaining a denser residential environment than what had been envisioned at that time in 2017. And thus we find it probably doesn't observe the spirit of the code. And as I said previously, criterion H, any other relevant factor, we as staff do not have any other factors we wish to mention, but the BZA may rely upon factors or evidence that is contributed by the applicant or other evidence that's heard during this hearing tonight. And that concludes my presentation. I am happy to take any questions from the board.
Thank you, sir. Well done as always. Board members, do you have any questions for Zach?
I have a question about the fire chief. So essentially, because the fence is gone, the fire chief's concern is now gone.
I believe his concern has been largely satisfied now that the fence
He really only talked about
has
that
been
fence.
removed.
Okay.
That was his primary concern. I did ask him about the location of the entrance to the two-story dwelling unit in terms of the depth from University Avenue, and he said that that was not a problem.
I'm sorry, who was that?
I objected
Thank
to
you.
his hearsay.
I just didn't see who did that.
Go ahead, you finish what you were gonna say.
I believe I've answered the question, so I have nothing else to say at
Good,
this time.
thanks.
Zach, are they going to remove, I drove by the property earlier, and there are still poles out there that, well, exactly. That would hinder an approach by a fire chief or a fireman. Are those going to be removed?
So I'm not able to answer that question in terms of whether those posts are to be removed. I think the question of possibly requiring that as a condition of variance approval, again, I think there is a valid health and safety concern in terms of obstructions to, in the event that there's an emergency for fire personnel to attack that emergency. I don't believe it is related directly to the request at hand, but you may pose that as a question to the applicant in terms of whether they would be willing voluntarily to remove those posts.
I will.
Quick question, Zach. Relative to the posts and the fence, as I recall, there was some question about who actually owned that or whose property it was on. Is that correct?
Correct. I asked that question of the applicant in an email. I did not get an answer to that, but as you will see, the fence has been removed, so you would be welcome to ask that question of the applicant.
Will do. Thank you, sir. Anybody else? No further questions. Thank you, sir.
Thank you.
And who's going to present for the applicant? Please state your name and job title for the record, please.
I'm Scott Webb. I'm an architect at 103 West Walnut Street, and I'm here representing the applicant.
Thank you, sir. Raise your right hand for me. Do you swear to tell the truth, the whole truth, nothing but the truth, matters before this board?
I do.
Please proceed.
Thank you. Well, good evening, Mr. Chair. I understand this is your last meeting, so hope we make this a fun one for you. I'm here representing Callista Enterprises regarding the redevelopment of the 314 site. Am I pushing the right thing? Got it. Got it. Okay. Just a little reminder here that Callista Enterprises, the progeny, so to speak, of the Helzer family, has just since 2018 invested about $5 million into the community in redeveloping properties in the Uptown, as well as creating new student rentals safer and better. And, they're asking to invest some more money in the community. So
Sir, well, I appreciate that. Would you please keep your comments to the property at hand?
I will.
Thank you.
Okay, so as Zach pointed out, this is the R3 MS zoning district. The little inset at the top shows you the proximity to the university. This is literally 2 blocks away by walk, directly to North Quad there. As Zach pointed out, this was part of the 2017 rezoning it from R1 MS up to R2 MS. The intention of Planning Commission was specifically that in areas that are adjacent to the university, maybe we should encourage some development in that area. And so that's why my clients are here this evening to redevelop this property. What we found, though, is that even though they rezoned the entire area to the R3, you can see from the map, every single lot in the neighborhood pretty much is 56 feet, like our lot is this evening. So even though they rezoned a huge swath of this section, R3, there truly aren't very many, if any, lot widths that do actually comply. That being said, we're asking for what we think is a very minimal variance. And I think it's important to point out that there are really 2 standards for lot size in 1137 OC. It is both lot width, which we're asking for a variance for, and lot area. And on my previous slide here, I kind of pointed out that while almost none of these properties meet the lot width requirement, they almost all meet the lot area requirement. And that is, in my opinion, the perfect opportunity for a variance. In fact, when we look at the purpose statement of our variance code, it says a variance permits variation from the strict interpretation of this code so that no specific provision prevents the development of a specific site. We're asking for a variance for one specific provision here, but it's, in my opinion, only half of the standard that is required for the 3-family lot. We, in fact, have 127% of the required lot area. Yes, we only have 93% of the lot width, but that's what a variance is for. If you have excess in one opportunity and less than required in another, that makes it a good variance case, in my opinion, and that's why we're here this evening. Since the 2017 rezoning, we have been granted some variances for lot width in this district. At 2009, or 209 North Campus, this was actually a project of mine I brought before this board. We had 80% of the required lot width, and that was determined as being not substantial. Tonight we have 93. At 112 South Poplar, also in 2018, we had 86% of the lot width. That was considered not substantial, both by staff and by the Board of Zoning Appeals, and we were able to proceed with that one. Again, tonight we're asking for 93%. And while every case has to be judged on its own merit, I understand how Board of Zoning Appeals work. We don't feel that the word substantial should be used in such an arbitrary fashion. So you have to judge this case on its merits, but the word substantial shouldn't be changing its definition from case to case. I think it's important to point out here that, as Zach mentioned, that this, the R3 MS zoning district has lot width variances to control density, to create some kind of a rhythm of the street, and to make sure that we're not really trying to put too big of a building on this particular lot. In this case, I always like to remind the Board of Zoning Appeals that we have a 35-foot height requirement, so we could certainly go taller here if we wanted to, but we have found a way to meet all of the other zoning requirements for this lot and keeping it as a 2-story structure, which we think is most compatible with the neighborhood. So as I pointed out, we have 93% of the width, we have 127% of the area. The side and rear setbacks are either met or exceeded, so the rhythm of the street, the proximity of this house to its neighbors is exactly what is prescribed by the R3MS district. We're not asking for any width variances. We're able to provide all the parking, all the sidewalks that you see from the front to the back of the lot, 2 sidewalks to the street, 3 private entrances, and still meet the lot coverage requirement. So we feel that this building is not too big for the lot if we can meet every other zoning restriction, side yard setbacks, excess rear yard, provide all the parking, provide all the sidewalks. So it shows that this project will in fact fit on the lot. And we're looking at what's honestly a 4-foot variance here, so the width of this lectern. And I would challenge anyone to walk up and down the streets of the mile square and tell me which lot is 56 and which lot is 60. I think the 4 feet is honestly imperceptible, especially when you're exceeding the side yard setbacks. It's also important to note that one of the goals of Planning Commission is to try to improve the parking there. This building, obviously as a single family house, had its own curb cut. Now, Planning Commission and presumably Board of Zoning Appeals approves parking off the alleys instead of on the street. So by eliminating a curb cut there, taking all the traffic and burying it back off the alley, that is a benefit to the neighborhood, we believe. Also, then we can remove the curb cut in the driveway that's currently in the front yard, which would open up maybe another parallel parking space on the street for visitors, since all of our residents would be accounted for. As Zach pointed out, we believe that the house is in line with the Mile Square design guidelines. And based on the Field Guide to American Houses, this house was designed as a version of what we call a Midwestern gable and front wing. And from the national style, it was very popular from 1850 to 1890. As you all know, with University in 1809, this is the era in which a lot of the Mile Square was actually built. So that's sort of why we chose this particular design style. And also, as Zach pointed out, we are providing 3 distinct entrances to the 3 separate apartments, all facing the street as the zoning code requires. Fire chief expressed concern over the location of the fence. In response, my clients hurried out there and took down the fence. To address Mr. Conrad's concern, taking the fence down was quite a bit easier than taking the posts that were set in concrete to do in a couple of days. But we clearly have no intention of leaving a row of posts as a side yard decoration here. So if you'd like to make that a condition that we finish removing the fence, we're certainly happy to do that. One thing I'm going to go back to the building just for a second. One of the things that we've done here, a lot of the houses in the Mile Square, as you know, have very tall ceilings. You know, we build 8-foot ceilings a lot now. This is built with extended ceilings on both floors. It allows for the windows to be set higher, to have bigger windows. It allows for transoms over the doors, which is again, you know, kind of a Mile Square sort of historic reference to include the transoms and larger windows and a better proportion for the windows, we believe. The decision standards do ask for any other factor. We believe that the comprehensive plan is a factor. It's our guiding document. We're currently in the process of creating a new comprehensive plan, but this is the one that we have in place at the moment. And there's a lot of chapters that we feel support this particular variance request. In the land use chapter, obviously we prioritize infill development and redevelopment of underutilized sites as a priority. We feel that this very tired single-family house that you see up on the right is a perfect candidate for redevelopment. It goes on to say to encourage the redevelopment and revitalization of existing underutilized student and non-student housing developments within the city over the construction of new rental housing. That's exactly what Planning Commission was talking about when they upzoned this area. I recall one of the members saying, you know, we've learned that you can't just keep stepping on the balloon and think it's not going to pop up somewhere else. So planning got proactive and decided, let's figure out where we do want the students to live and let's change the zoning to encourage them to live there. And so that's kind of where we are now. And I think that speaks directly to the goal of the comprehensive plan. Rather than sprawl and let the students spread out farther, let's keep them kind of corralled next to the university and increase the density as needed to make that happen. Likewise, in the housing section, they talk specifically about enhancing the neighborhoods within the Mile Square, improving rental housing. We certainly believe that this will do both of those. Redevelopment of existing residential areas to have a strong neighborhood quality, maintaining the small town character. You know, we feel that the design guidelines that Planning Commission and City Council put in place work toward that end, and staff seems to agree that we are providing a historically appropriate and compatible design for this site. We want to continue to foster a high-quality community with a distinct sense of place. That's why we're not doing vinyl siding here. This is a brick house. This is a historically designed house. We want to continue pedestrian connectivity and walkability. We're eliminating a curb cut, connecting sidewalks everywhere that we can connect them. And it suggests, the comp plan suggests we investigate off-street parking solutions, which I believe that we have provided in this particular case, and improved on-street parking by the elimination of the driveway. So I have a different read on the decision standards than staff does. Whether the property in question will yield a reasonable return, we believe that a reasonable return can be achieved by providing the principal permitted use that was expanded by the rezoning of the area. So, you know, when opportunities arise, when zoning changes, regardless of what it was when they bought the property, it's the applicant's opportunity to reinvest in his property and in the community. And so, yes, there may be some benefit of an existing single-family house there, but we don't believe that that particular standard is designed to preclude you from trying to do more on your property. Just because you have something that makes money doesn't mean if the opportunity to grow it is there that you don't take that opportunity. Whether the variance is substantial, we believe this variance is clearly not substantial. As I said, I believe 4 foot is imperceptible, as a lot with if you were walking by in the neighborhood. And as I pointed out, you know, staff seems to want to focus on half of the standard, the lot width standard, but really isn't addressing the lot area standard, which goes hand in hand. In this case, we have an excess of area. We believe the essential character of the neighborhood would be improved with a new building, more historically appropriate, designed in accordance with current building codes, safer, and the mile square guidelines, providing the required parking. Whether the delivery of governmental services would be affected. Obviously, my clients jumped at the opportunity to attend to the fire chief's concerns, and we'll continue that and get that fence out of the way there. Whether the property was purchased with the knowledge of the zoning restriction. As Zach pointed out, this property was purchased about 3 zoning restrictions ago. I mean, zoning changes, zoning is a fluid document. We hold public hearings when we change the zoning map, so people are aware of their opportunities to improve their property. So yes, it was zoned to R1 at one time, but and yes, they knew about it, but I don't think that works against them to want to be able to reinvest here. Whether the property owner's predicament can feasibly be obviated through some other method. As Zach pointed out, these lot sizes were set probably with the original plat of the city in 1800, whatever that was, 1811 or something. So we don't have the opportunity to buy 4 feet from the neighbor in this particular case. But again, I go back to the fact that, you know, we have excess area and a little less width. That's what makes it a good variance case, in my opinion. We also disagree with staff. We believe that the spirit and intent of the zoning code is considered in this application for a couple of reasons. This is considered a principal permitted use. R3 in an R3 district is a principal permitted use. And we have this board and we have the chapter of the zoning code called variances. This standard that we're looking at, the Duncan standards, is not specifically about R3. It says, does it substantial justice being done in the spirit and the intent behind the zoning code. The zoning code in its entirety takes into account variances. In fact, it describes how you go about them, and so this is why we're here. This is an opportunity to exercise the rights, and as I pointed out from the purpose statement in that zoning chapter, it's set up so that no specific provision prevents development of a specific site. We feel that that's exactly why we're here. And lastly, the other relevant factors, I think I pointed out to you how we feel that we comply with the comprehensive plan, both the goals and the objectives. And I'd be happy to answer any questions that you have.
Thank you, sir. Well done as always. Mr. Conrad.
Who owns the fence?
The applicant.
All right.
I mean, they can't take down their neighbor's fence.
I appreciate him asking. There was a question we got it clarified. Excuse me. Mr. Minier?
I
Mr.
got a
Engel?
question. Does the current single-family house abide by the width regulation, or does it exceed it?
I'm certain it applies, it complies. I mean, there's a whole driveway to the north,
Yeah.
and it's not over the setback to the south side as far as we can tell.
Okay.
Mr. Allison, you have anything?
You said that, obviously, a three-family would give greater return than a two-family.
Sure.
But are you saying that a two-family would not return reasonable profit?
Well, I'm really not gonna mix that up at this point. I mean, you know, the math is the math. I mean, the two-family would generate more income. You know, the three-family would generate even more. They're also more expensive to build and more expensive to maintain. So, you know, whether or not the numbers completely flesh out, you know, that's a decision for my client to make.
Anybody else?
I think I have one more question. I think I'm allowed to ask this. I'm not telling me if I'm not. Could a two-family house be built without exceeding the width regulation?
Sure. Well, just to be fair, our building isn't exceeding the width regulation. The lot is the width regulation. And as Zach pointed out, 50 foot is the minimum for a two-family, and 60 foot is the minimum for a three-family. So we have the lot width for a two-family.
So you have the lot width for a two-family. I guess that's
Yes.
that's the way to put it. Okay.
Anybody else? Thank you, sir. Is there anybody else who would like to speak before this
Excuse
board?
me. I'm an attorney, Jack Grove, and I'm here representing the applicant tonight, just in an advocacy role, not as a witness, but I do have a question of Scott before he sits
Scott,
down.
approach the podium.
And this does bear upon the investment and return. Approximately, in your knowledge of construction costs, what is the investment for this three-family as is proposed with this kind of architectural detail and brick?
Sure. I mean, based on the size of the units and the development cost here, I think we're probably looking at between $750,000 and $1 million. It's not uncommon for a single unit to cost $250,000 on its own right now. So 3 units plus the site work and the demo and everything else could be anywhere between $750,000 to $1 million.
Thank you, sir. Board members, anything else? Mr. Grove, do you have something?
Yes, I'd like to introduce Greg Dale as the next witness. Mr. Dale is a land planning expert, known nationally for his work, and he has a report he would like to share and render his opinion having to do with the Duncan decisional standards that we're discussing tonight. I have the entire text of the report. I'm sharing it with the clerk, Mr. Connor. Mr. Moore.
Thank you, sir.
Thank you, good, thank you.
Mr. Dale, would you step to the podium, please? Please state your name and title for the record.
Greg Dale, I'm a principal with the planning and zoning consulting firm of McBride Dale Clarion.
And raise your right hand for me. Do you swear to tell the truth, the whole truth, and nothing but the truth in matters before this board?
I do.
Please proceed.
Great.
Could I have one point of clarification to supplement the record? What is your business address, please? Because I don't see it on the report.
Yeah, 5721 Dragon Way, Cincinnati 45226.
Thank you.
227, I'm sorry. Thank you. Mr. Chairman, members of the board, I've been asked by the applicant to review the facts relevant to this case and share my thoughts about them, and that's what I would propose to do. I was not involved in the planning of this. I was not involved in the design of this. I was brought in as the application was being filed. So what I'd like to do is to walk through the same decision-making standards, the same factors that you've heard. And I do have a different take than staff. I appreciate staff's professional presentation, but I'd like to add maybe a different perspective on that. But just by way of background, I indicated that I'm a principal with McBride Dale Clarion. That's a planning and zoning consulting firm. We have practice here in the region, but I've worked nationally with communities all over the country. I've drafted zoning codes, I've drafted comprehensive plans, I've been involved in many of the same kinds of issues that you have here before you. I've also been asked to mention that I have actually been qualified as what in court is referred to as an expert witness in county courts and federal court in a variety of different zoning cases. I've also done over the years a lot of work in training, planning, and zoning commissions, and also specifically boards of zoning appeals. And I want to be careful, that doesn't mean that I'm better qualified than you all to assess the facts. I just want you to understand I spent a lot of time in my career working with communities to think about how to weigh evidence. And ultimately your responsibility here is to weigh evidence. I'm going to talk about the factors that you have before you. I think the board probably understands that none of those factors are controlling. You don't have to meet all of them. You weigh those factors in coming to your conclusion. That's what I'd like to talk about. So, you know, what I did, I came in, I reviewed the plans, I've walked the neighborhood, we put together some maps that I'm going to share with you that are actually in the report, reviewed the code, reviewed your comprehensive plan, which has been mentioned here, which is a very significant issue, and I did review some of the staff reports on other cases, and I'll talk about that as I go. So I'd like to just jump into the different factors. Some of them I'll hit lightly, and some of them I'll spend a little bit more time with. Factor A, the issue of the question of whether or not the property in question will yield a reasonable return, or whether there can be any beneficial use of the property without the variance. So it is true that a single family and a two-family building can be built meeting the lot width requirements. But one of the things I want to point out is the three-family is not just something to be reluctantly accepted. The three-family is actually referred to in your comprehensive plan as one of the, quote, preferred uses, along with single-family and two-family. And that's, you know, in furtherance of the kind of urbanist principles that are in your comprehensive plan. This area, this neighborhood, and I'll talk about neighborhood a little bit differently maybe than you've heard tonight, is specifically encouraged to have this use. It's not a reluctantly accept this use, and I think that kind of sentiment has seeped into these discussions here. The three-family is just as preferred as a two-family or a single family. In fact, when you read the purpose statement of the R3MS, it specifically refers to three families. Three-family is actually in the title of the district. So again, three-family is not a secondary thing that only cuts, you know, one way. And my point there is this term beneficial use, which is in the factors, is not defined in your zoning code. There's no guidance in your zoning code as to what that means. So beneficial, benefit, the benefit certainly is beneficial to the property owner, but if you look at your comprehensive plan as actively encouraging this use, I think you can make the argument that it's beneficial to the community as well, and I think that's important to understand. The question of whether the variance is substantial, 40 feet over 60 feet, is obviously one of the factors. Substantial, the term substantial, is also not defined in your zoning code. And what your zoning code says is that when a term is not specifically defined in the definition section of the zoning code, you essentially use the common dictionary meaning of the word. So I looked it up in multiple dictionaries. The word substantial, the common theme that runs throughout that is large in size. That's basically what we're talking about. Is this variance large in size? Mr. Chairman, should I keep going?
Please proceed. Please keep your comments to yourself. Thank you.
So I'm also aware that your zoning code actually discourages the consideration of other variances that have been granted. And I want to talk about that, because the question of whether or not this variance is large in size is substantial is obviously a judgment. Staff indicated that in their opinion it is substantial. I appreciate that perspective, but you notice there was really no rationale, no factual basis for coming to that conclusion. It's just their judgment, and that's fine. That's their professional opinion. But when you look at how the city has applied that question in other instances, it's clear that it's been looked at differently. And I want to talk about that in just a minute here. But one of the things I want to talk about, I want to be careful here because I'm not an attorney, but as a planner, particularly in the kind of work I've done, I'm expected to understand what some of these legal principles are as they apply to us as planners. Your 7 factors here, 8 if you count the other. Your factors here that you're considering are verbatim taken from an Ohio Supreme Court decision that planners in our business and the kind of work that I do are very familiar with. It's the Duncan versus Middlefield case. It's the Ohio Supreme Court that basically said, when you're considering this question of practical difficulties, here are the factors that you consider. And what Oxford did, smartly, is just pull those into their code. If the Supreme Court says those are the factors, we're going to make them the factors in our code. Just like other communities have done, we've written zoning codes that put those same factors in to guide you in decisions about whether or not the practical difficulty is met. But what Duncan says is interesting on this point of substantial. If you actually read the Supreme Court case, what the court says is we can't make a judgment on this particular case, this Duncan family that was building in the village of Middlefield. We can't make a decision on whether or not the lot width is substantial because no one talked about what other cases, other examples were being applied in the community. So the very case that put these factors into your zoning code says that substantial has to be looked at in the context of what has happened in other cases. I won't go through all the details again, it's in my report, but you heard the architect talk about 2 other cases where greater percentage variances were considered to be not significant in those cases. One of them is in the same district, in the R3 MS district, the one at 112 Poplar Street, which I think is actually now 114 Poplar Street on the ground, was proposing a 8-foot variance, twice the variance that we're talking about here. Same regulation, same 60-foot lot width, 8 feet, twice the variance, was determined not to be significant here. So I think that's something that the board can and should consider. The other thing I would point out in terms of that context, we put together a map that I'll share with the board where we did some analysis. Oh, wait, that's actually the map. This map is in the report, but I just wanted to have it freestanding so you could look at it. So the R3 MS district is what's depicted on here, the one in the northeastern quadrant of the mile square. And I'd like to point out that what we did using GIS off of the county's website is simply to identify those lots that do not meet the 60 feet requirement and those that do. And the architect made the point, which I agree with. If you go out and you walk the streets and you look at these, other than some of the corner lots that are obviously different shape, if you go look at those that are 60 feet and those that are slightly less than 60 feet, me as a planner, I can't see the difference. To the human eye, to my eye, I can't see the difference. And I want to point out a couple of things. So you can see the site highlighted there in the middle of the page on University between Sycamore and Vine. And you can see that it's one of 6 different lots that are in that area. So I would suggest then that once you look at that you go over to the west to North Poplar, also between Sycamore and Vine, and look on the east side of Poplar, and you see all those that do comply, and there's the same number of lots in there. Again, the naked eye can't detect those. So we've written zoning codes. I know what these dimensional standards are like. 60 is a round number, right? It could have been 58. It could have been 62. There's no science to that. Typically what planners do is they look at context, they look at prevailing lot sizes, and they come up with what they think are reasonable estimates for what that lot width should be. I would suggest to you that I think it's highly unlikely that someone sat down and specifically said, all of these lots in red, we don't want to have 3 families, and all of the lots in white, we do want to have 3 families. So the point is that there's really no logical reasons why you would say on that Poplar side, we want all of those to be 3 families, one of the preferred uses, and on this block, we don't want any of them to be. When again, you walk around, same context, same neighborhood, same general pattern of buildings and so forth. So I would suggest that that's an important consideration for the board to keep in mind. The next factor, factor C, is whether the essential character of the neighborhood would be substantially altered or whether adjoining properties would suffer a substantial detriment as a result of the variance. Notice there's two different terms there. It's almost like it's two different factors. Is the essential character of the neighborhood going to be substantially altered, and are adjoining properties going to suffer? So let me take those one at a time, and again, I would like to pass on one more map for you to consider. That's also in the report. This is a map that was prepared based upon the auditor's definition of uses. So first of all, I'd like to make a distinction when we talk about the character of the neighborhood. So what staff talked about was the block in which this is located on. When I think of neighborhood, I think of something larger, a larger context. I think of something that looks more like this R3 MS district. There's probably a reason why this area was zoned R3 MS, because it has common characteristics that I think would be more characteristic of a neighborhood. And what I point out in there is you can see that there's a mix of single family, two family, three family, commercial housing and apartments, which is what the auditors call it. And those are things like fraternity houses as well. There's even a retail use in the area. So that existing context, that neighborhood, I believe if you look at this map, a three-family in this location would be perfectly in character within the essential character of the neighborhood. The other thing that I would point out when we talk about essential character is you can look at it both as existing character and as desired character, right? So the desired character as represented in your comprehensive plan, as implemented through the zoning regulations, is part of that. I attached a number of different excerpts from your comprehensive plan. The architect talked about those as well. I would point out, though, that in your comprehensive plan, specifically on the map that refers to a neighborhood enhancement concept area, this area is specifically shown as that designation, and multifamily, that's where the term preferred use comes in. There's no question that three-family, multifamily is designated as a use that's appropriate in that area. And I'll also point out, this hasn't been mentioned yet, but your economic development staff, the city's own staff, referred to this as a, quote, positive change in residential development and infill in Oxford. The other thing I point out in terms of the adjoining properties, which is the other term that's within that factor, is the idea, and the architect talked about this, the idea that when we look at lot width, you have to look at that in concert with other dimensional standards. And what's happening here is that the setback requirements are exceeded. And specifically, they're exceeded by my estimate, my scaling, by 7 or 8 feet or so. So when you look at the 4 feet lot width that the variance is requested from, that's more than offset by increased setbacks. So in terms of impact on adjoining properties, a single family or a two family could actually be built closer to the lot line than what's being proposed here. I hope that makes sense, because I think that goes to the issue of the adjoining property factor in there. Factor D, whether the variance would adversely affect the delivery of government services, i.e. water, sewer, garbage, that's already been discussed. We think everyone agrees, staff included, that factor is now met. Whether the factor E, whether the property owner purchased the property with knowledge of the zoning restriction. It's always been an interesting one to me. Anybody that purchases property should know what the property is zoned, right? I mean, that's part of what you look at. But what's interesting here is if you just read this on its face, did the property owner know when they purchased the property that this zoning restriction existed? They didn't, because this district didn't exist at that time. The zoning map has been changed. If I understood correctly, 2 different text amendments have been passed. So clearly the property owner, when they purchased this property in 2000, couldn't have known about this zoning restriction. Whether the property owner, or I'm sorry, factor F, whether the property owner's predicament can be feasibly obviated through some other method other than a variance, again, it depends on how you look at it. Yes, you could build a 1 or 2 family there, but you can't build a principally permitted use that is specifically encouraged in the comprehensive plan with this without, as the architect said, trying to buy 4 feet from somebody else who doesn't have the lot width to sell either. And then finally, the question, factor G, whether the spirit and intent behind the zoning requirement would be observed and substantial justice done by granting the variance. I'm not going to repeat the discussion about the comprehensive plan, but when you look at the spirit and intent of the zoning regulation, clearly zoning regulations are a tool to implement the comprehensive plan. So when you look at the spirit and intent of a zoning code, you should always look at the comprehensive plan, but that's already been discussed. I just would reiterate that the issue of lot width, let's think about what the purpose, the spirit and intent of lot width is. It is to preserve essentially adequate spacing between buildings. You know, staff described it as predictability in terms of spacing. Again, the lot width variance that's being requested here is more than offset by the setbacks. So the buildings could actually be built closer to the other buildings for a single family and 2 family use. So in terms of the spirit and intent of the lot width is more than being met with that offset. The other thing the staff noted is this predictable ratio of building size to lot size, and that this would result in a denser residential environment. Lot size and density, those are a function of lot size. The minimum lot size required here is 8,000 square feet. This lot has more than 10,000 square feet. So from a density perspective, from a ratio of building to lot size, it's actually lower than what could be permitted. It's actually a net gain in terms of the ratio of lot size to building size. So just in conclusion, let me just kind of sum up. I think the variance would benefit the applicant, no question about that. They wouldn't be here if they didn't see a benefit in it. But it would benefit the community by providing a use that's specifically provided for here. 4 feet, which is less than 7%, is not substantial according to how the city has applied that in the past. The city has already concluded that a variance in the same district from the same lot width requirement of twice the size here was determined to be not substantial. The other point, think about this, a single family or 2 family could actually be built closer to the lot lines than what's being proposed here. The structure exceeds the setback requirements. Again, I think more than offsetting any potential impact of a slightly narrower lot. And then with the 10,000 plus square foot lot size, even with the variance, the density of the site will be substantially less than what's required by the code. So based upon that, Mr. Chairman and members of the board, I realize your job is to weigh all of this evidence. I believe, you know, from my professional opinion perspective, that there is, in fact, reliable and substantial evidence that the dimensional variance meets those decision factors. And thank you for your patience in that presentation. I'd be happy to try to answer any questions that you have.
Thank you, sir. Before we go any further, I want the record to reflect that we have 2 handouts given to staff and to the board by Mr. Dale. One concerning lots in the R3MS district in question, showing lots of less than 60 feet, and the second handout in the same zoning district showing land uses in the R3MS zoning district. Just want to have those in the record.
Well, and to further clarify, both of those maps or exhibits are contained in the primary report. These are just blow-ups.
Okay. Very good. Board members, do you have any questions?
Yeah, thanks, Mr. Dale. I have two questions, just for clarification. One is about these 2 maps.
Yes, sir.
So the one map has lots with less than 60 feet of width, and they're a bunch of red. Those
Yes.
properties are marked red. And the second one says land uses in the R3MS zoning district, which is the same district, and it notes properties in red that are 3-family dwellings. So my question is, how many of the lots with less than 60 feet of width have 3-family houses on them? And I came up with 2. out of about 30. One is on North Campus at about East Sycamore Street, and one is on Bishop at about Vine, I think. Does that match with what others are thinking? So I sort of tried to overlay the two maps to figure out how many lots with less than 60 feet of width in the R3MS zoning district have three-family houses on them. And out of about 30, I couldn't count all these lots, but out of over 30, I came up with only 2, I believe.
That's a good question. I did not specifically look at that. You have a quick eye in coming up with that, but I did not specifically look at that.
That's of interest to me because we are talking about a three-family house in a lot with less than 60 feet of width. Then my other question has to do with the Board of, and I didn't have time to read all this, but your exhibits, the staff reports of the Board of Zoning Appeals for South Poplar Street is on page 38 of this little booklet, and on page 42, I think. There are 2 staff reports, one for South Poplar Street and one for North Campus Avenue. And in both cases, the staff recommended not supporting the variance. I don't know how the board actually voted. So South Poplar and North Campus, the staff did not support the variance request. This also had to do with minimum lot width.
Yes, another very good question. I was focusing specifically on the determination of substantial or not substantial. And in both cases, staff concluded, offered the opinion that it was not substantial. My understanding, and I believe we have copies of those resolutions that others will enter into the record, is that both of those were approved.
Yeah, the court has, they're in the back of that book, the resolutions from the zoning board where they were approved.
So the board and the staff recommended against approval, but the board ended up voting, which often happens, or
Right.
sometimes
That's my
happens.
understanding.
Okay.
Here are the 2 DCA resolutions. I don't have multiple copies, but
Okay.
those are the resolutions. The board determined that the variance should be granted, even though they were both larger.
If I could just go back one question, if I could. One of the things that I think is worth thinking about is the lack of 3 families that you're seeing there can be explained at least in part by the fact that 3 families were only recently permitted with the amendment. So there's not a long history of the ability to construct 3 families.
Board members, anything else? Thank you, sir.
May I ask a question? I've got a question for point of clarification. Your focus was obviously on 3 units.
Yes.
But based upon the diagrams and the maps that you showed, a number of the properties there would support a 3-family because the lot width is wide enough. Is that right?
Yes.
And you're suggesting that, if I understand your testimony, that the fact that there are 2 families allowed wasn't a conscious decision in some way by the council that passed the code?
Right.
To say that there's variations in lot width, therefore we would allow 1, 2, or 3 by way of infill, and somehow that's not consistent with that comprehensive plan that was encouraging the infill.
Right, so the comprehensive plan identified this entire area as being appropriate for 3-family. I think, though, to clarify my comments from earlier, my point is when the comprehensive plan suggests all of this area is appropriate for 3-family, it's all zone R3MS. And yet, because of what effectively are historic accidents of some of these lots being 58, 56 square feet, that the net result of that being the pattern of what's permitted for for 3-family and that's not, would, to me, border on an arbitrary distinction that's being made. There's nothing that I could find in your record, in your comprehensive plan or your zoning code, that says these lots in red are not appropriate, those lots in green are not appropriate. And also, again, I want to just keep in mind that lot width is one of the tools in concert with things like a lot area and setback requirements, and on all the other points, those are more than offset, or those more than offset the lot width issue we're discussing.
But wouldn't that, what you just talked about in terms of lot width, have been taken into account of lot size by virtue of the fact that the zoning allows for single, double, or three-family housing? So by having variations in the lot size and dimensional standards, wouldn't that account for an explanation of why single, double, and triple
I
family?
appreciate the question, and I can't put myself in the place of ultimately city council when they adopted this. But when you look at the condition on the east side of Poplar versus what we have here, 6 lots that to the naked eye look exactly the same, at least to me. And to say that all of those on the east side of Poplar were thought to be appropriate for 3-family, and all of those along this stretch of University were not thought to be appropriate, frankly, I just think that defies credibility, whatever that word is.
That's the right word.
Thank you.
Okay. I don't have anything else.
I got one more question. Did you say that 3-family housing is in the comprehensive plan?
Yes.
Can you point that out somewhere? I'm in the housing, you've
Yeah,
attached that.
it's actually in the map. So if you work your way back about halfway through the book, and you'll see the map and then a matrix that looks like this.
Oh, I see.
It actually refers to multifamily, which is, so it refers to single family, 2-family, and then multifamily, which is anything above. So actually, 4-family and 5-family are
Or apartment
preferred
complexes.
uses. Or apartment complexes are, yes. Because this is in that purple color, the neighborhood enhancement on the map.
Okay, yeah, I see, it's the mile square, the purple color, neighborhood enhancement.
Right.
So then you go back to the matrix, and it says neighborhood enhancement area north of Spring Street around Uptown and Homestead. Yikes.
And then you go all the way over to the right where it's got the check marks.
I see, single family, SF, TF, 2-family.
And then,
I see, ASF, attached single family, multifamily, okay.
Yeah.
So in the comprehensive plan, to review, the mile square area was identified as a place that would be good for those kinds of housing, a variety of housing options, including single family, 2-family, attached single family, and multifamily. Okay.
right. And that, in fact, I think is reflected in the actual pattern that was the other map that I distributed to you all.
Board members, anything else? Thank you, sir.
Thank you very much.
Is there anyone else that'd like to speak to this case?
Yes, Jack Grove again. I would like to share some perspective as an attorney doing land use work, zoning, from the outside in. Of course, I've been doing zoning cases in Oxford, this city, for over 40 years. And I handled the Tempo case a long time ago involving fraternity housing that went on up, and it actually changed some of the law in Ohio at the time, having to do with making a record and how council that acted on the conditional use permit rather than the zoning board had to act in a quasi-judicial capacity. And that's what this board does. It's quasi-judicial, as you're well aware from your experience, Mr. Schmipper and the others. You're not making your own policy, but you're applying this particular code. In Ohio, we have 2 different kinds of uses, or variances, excuse me. A use variance, which means changing the use to something that would not be permitted in that district. For example, if you have single-family residential exclusionary zoning, a use variance would be an example, putting a 3-family in a single-family residence. And years ago, we had mostly exclusionary zoning, all R1, all multifamily. We didn't have this blending and mixing of neighborhoods. An area variance, on the other hand, is changing a dimensional requirement. Perhaps it's a setback, perhaps it's lot size, and it's a much different standard. For a use variance, you must show a hardship. And that's why you look at the property owner's original knowledge when he acquired it, because you can't have a self-induced hardship. Area variance, hardship standard does not apply. The Ohio Supreme Court stated many, many years ago that it's a practical difficulty standard. And the notion behind that is that if there is some practical difficulty having to do with the dimension of this lot, ought we change it to accommodate the intended use? So the question that you have before you is, if we relax the 4-foot requirement, can we accomplish other objectives? And those objectives are stated in your comprehensive plan. The comprehensive plan, when it was adopted back in 2008, said that it is a using document. Staff is supposed to cite the comprehensive plan in rendering its reports and making its decisions. The zoning board is supposed to look at the comprehensive plan. I don't know if any of you were around at the time, but at Scheidler Hall, many of us were invited to a speaker on new urbanism, and it predated the comprehensive plan. The speaker was nationally renowned. County commissioners were there, city council folks from all around the county, zoning administrators, township trustees, zoning board members, law directors, anybody involved in land use was welcome to attend. And it was through the Harry Wilkes Conference Center that this speaker was brought to our community. And he cited communities like little New England villages where there were mixed uses and how walkable they were, and tried to explain that the exclusionary zoning that did not invite that blending of uses maybe wasn't the best way to conserve our land use, and it was a way to avoid sprawl. Well, I want to tell you that Oxford Council embraced new urbanism, and so the comprehensive plan speaks to walkability. And I might add that walkability to campus, this is only 2 blocks away. They talk about redevelopment, encouraging improving housing stock. And anybody that looks at the photos knows that this is a vast improvement over the structure that's already there. It's a major reinvestment. Mr. Schnipper, I think you reacted a little bit to Mr. Webb's explanation about other investments of this property owner. That's really meant to rebut comments in the staff report, and I'll explain. To the effect that the property owner acquired this, so that means it was a single family and that was his stated long-term investment-backed objective. I say not so. I've worked with this portfolio of properties for over 20 years, and there have been major redevelopments, including historical renovations, one that received an award from the city on High Street. So the long-term investment-backed objective is improved land use utilization, reinvestment, replenishment, reinvigoration of this community. And that is the tradition that this property owner has exhibited consistently. It's a large portfolio. This is a rather drab structure that's there right now, unremarkable, not consistent with the historical character of the mile square. When I moved to my farm in Oxford Township, my late sister-in-law, who was a DeWitt, and for those of you who know, the DeWitts were original settling family members in Oxford, back in the days before the university even. She gave me the 1875 atlas of Oxford Mile Square and Oxford Township, and it hangs in our breakfast room. And I see these lots that are laid out, ones that we're talking about today, that harken back to well over 100 years ago. Nobody contemplated that we would be doing this today. So I think that we're asking for something that's minimal. Other communities I go to would say this is not significant. We can accomplish so much of a betterment by allowing this relaxation. It's called ameliorative, that we can lessen this restriction, but we're exceeding all of these other lot density setbacks and bringing a beautiful, lovely, more remarkable up-to-date, safer structure compliant with current codes. And that's what this property owner would be delivering with this board's assistance if we can go forward. So that's what I have to share with you.
Thank you, sir.
One final comment. Justice Brennan, late Justice Brennan from the United States Supreme Court, cautioned that if police officers need to know the law, so do land planners. We've heard a lot about legal discussion tonight, and perhaps, some of us don't like to get into that, but it really guides us in our decision making. And so we know from other cases how the courts look at these things, and that's why we're having this legal discussion, because it guides us all in our approach to this. I want to thank you. Everybody's paid close attention, and I really appreciate that. Thank you.
Thank you, sir. Is there anybody else that'd like to speak to the board?
Yeah, I'll speak.
Please state your name for the record.
Tony Miller.
And Mr. Miller, do you have standing to testify in this case? Meaning, do you live within 200 feet of your own property?
I have adjoining property right next to the property they're trying to do.
Thank you, sir. Raise your right hand for me. Do you swear to tell the truth, the whole truth, and nothing but the truth matters before this board?
I do.
Please proceed.
Okay, so basically the whole thing about this variance is just to put more people on the property. Not about all the beauty and all this other crap. It's just, adding four more people. And the guy's showing us map reading stuff, as he did the map reading when students are in town and the alley's full of cars. So basically that's all I'm saying is that the variance is nothing but just to get more people on the property. And if it's passed, then I guess I can put another unit on the back of mine, because they're right behind his properties. Understand that? Or do I need to say more?
I think you're fine. Board members, do you have anything, Mr. Miller?
Any questions?
My only question is, which property do you own, like on that?
Right behind, directly behind the property.
So it's the one on North, is it a North Campus Ave address?
Yes,
Yeah, okay,
317 and 321.
I see.
Right.
So it's north,
So I guess, God, you
Yeah,
decided
that-
to put the property for me back here, right?
I can't hear you.
Huh?
Mr. Miller?
Oh,
I couldn't hear you.
I just asked,
Is that
I asked Scott, would he design another 4-unit for me then?
Thank you.
So I got some questions.
Okay, all right, Jack.
Okay.
He's my neighbor.
Yeah, we're neighbors. And we're friends. So I got a question for you.
What? Oh, for me?
Yeah. You don't live at the property that's next door, right?
I own it.
You own it, right?
Yeah.
How do you use it?
It's student rental.
Oh, okay, so you're a competitor, right?
Oh, yeah.
Okay, that's fine.
Yeah.
it's a two-family,
Question, right?
Yes.
Okay.
according to this map, Mr. Miller, that house is a single-family house.
Well,
on it.
originally, the city of Oxford made me consolidate the lot because it was a split lot on 317, and Kathy Dale made me consolidate it because it was 2 lots there on record Butler County. And then the city of Oxford made me consolidate it just to put one up, and then they changed the zoning stuff, and then so they allowed me to put another unit on the back.
Oh, so how many units are on that property? I know this is not really our case, but I'm just,
It's 317 and 317 and a half.
so there's,
So it's just 4 and 4.
okay, there are 2 single-family houses on there, I see. Okay.
Right. Which is allowed.
Okay, I got it, yeah, okay. Okay, thank you.
Thank you, sir. Board members, anything else from Mr. Miller?
Pardon?
We're just making sure that nobody has any further questions.
Oh, okay. I'm still here.
We're good. Thank you, sir. Anybody else? Okay. I need a motion to exit adjudication and re-enter regular session.
So moved.
Thanks, Mr. Allison. Mr. Conrad seconds. All in favor, say aye. Opposed? Without opposition, we're back in regular session.
Mr. Chair, can I make a recommendation at this point before you go into whatever deliberations you do? Given the fact that we've got multiple exhibits, I think that we ought to, for purposes of the record, identify them as to what they are in the event however this plays out, whether there's an appeal or not. Mr. Grove, does that make sense to you?
Yes, I agree.
Okay, so my suggestion would be is that we use numbers, and that Exhibit 1 would be the staff report that was presented by Mr. Moore, and that his PowerPoint be Exhibit 2.
Okay.
Then, I don't think that there's anything else until the applicant made a presentation, and that the applicant's report that was presented by Mr. Webb was contained within the staff report. Is that a fair statement?
Staff has my PowerPoint.
Okay.
Yes.
Well, but did you have a separate PowerPoint, or was that part of the original application?
PowerPoint, but it was submitted to the city. prior to
Okay.
the-
Okay, well, should we identify that as a separate exhibit then? 3?
And you have the application also, which ought to be the very first.
Okay, well, you're right, so add the application, the applicant's application would be Exhibit 3, the applicant's PowerPoint would be Exhibit 4. Then, we've got Mr. Dale's report, which would be Exhibit 5.
Yes.
And then we have the 2 blow-ups of the exhibit, and we'll start with the lots less than 60 square feet would be Exhibit 6.
Yes.
And then the land uses in R3 MS zoning district would be Exhibit 7.
Yes.
Am I missing anything?
Yes, the two
Oh, yes,
prior
yes, okay.
BZA resolutions where they approved the 8-foot and the 15-foot.
All right, so for purposes of this record, we will, this is by reference number BZA 2018-6, related to 112 South Poplar, will be exhibit, are we on 8 now?
Yes.
Okay, and then BZA 2018-09, related to 209 North Campus Avenue, would be exhibit 9. So I think that's everything.
Okay.
Okay. Anything else, Jack?
No, sir.
Okay. All right, that's all I wanted to do for purposes of the record.
Just for the purposes of the record, do we want to go through each one of those for the staff, or are we going to be satisfied with Mr. Conrad's summation?
I'm good with that summation.
Mr. Conrad? I am also. Let the record show the exhibits and their corresponding numbers as suggested by legal. Okay, now we can start deliberations and or motion.
Are we ready for, can we do deliberations now? Did we
Yes.
make the motion for that?
Yes.
Okay. Okay. I want to start my deliberation. And thank Mr. Grove for reminding us that this is about the law, because in fact, by law, we are debating here minimum lot width for a 3-family use. We are not debating diverse housing stock or land use issues, or even the total lot coverage, which Mr. Webb suggested that we think about. But our job here is to review a variance request on the minimum lot width for in this zone is 60 feet for a 3-family house. And so the variance request is for a reduction of the 60 feet regulation for a 3-family house. So that's what we're deliberating here.
Correct.
Okay. There was a lot of other stuff that was said, and I just want to clarify that part. And I'll follow up just by saying that I was part of the planning commission that recommended the upzoning for this area, and I do agree, I follow and support the philosophy of increasing densification in this area, but I also really like and agree with the staff report that said that upzoning, the intent was not to allow 3-family on every property just for the sake of increasing density. So we can increase density, but that doesn't mean there's no one ever said in that planning commission meeting how much density we were going to increase it. It didn't mean we were going to suddenly put like high rises in there or multifamily or even 3-family. So that's my understanding of the intent of that upzoning. And so, I think I'm done with that.
I appreciate your concern, Larry, but as was pointed out, in this zoning district, 3 families were the preferred. It's not that they're trying to fit it on every one, but it is preferred housing stock within that district.
I never saw the word preferred. Where do you see the word preferred?
In the comprehensive plan?
Comprehensive plan, it was one of the options, single family, two-family, multifamily were all the options for that area. And then the upzoning gave allowances that we could increase density, but nowhere did it say we prefer three-family housing here. And in fact, although it is true, as someone mentioned, that three-family housing is sort of a new option here, it is also true that in that area, in that upzoned area, only 3 lots with less than 60 feet of width have three-family housing. Only 2, sorry. Of the lots with less than 60 feet of width in this area, only 2 have three-family housing out of about 30-plus lots of less than 60 feet of width. So it's actually, at the moment, a minority. That doesn't mean it has to be that way, but it is not. It seems that in the upzoning process, what's happened is a lot of people have put in two-family houses or 2 single-family houses, like Mr. Miller.
Okay.
Okay.
Mr. Conrad, anything?
No.
Mr. Allison?
Okay, so and I happen to agree with what you've said. And noticing the recent development, which is the slide that's up there right now, you can see that people are building single and double. They're not building three-family. That said, I often look at, when we talk about a variance, I look at whether the person has taken advantage of us. For instance, if he had built the building, was proposing a building that extended beyond the setbacks, I would be very much against this. But he didn't do that. So I'm looking at this and saying that from the perspective of maintaining the neighborhood, he's accomplished that. From perspective of improving the neighborhood, there's no question, but that's been accomplished, would be accomplished by doing this. So I'm still on the fence here, because I think our primary charge is to find that there is a substantial reason to violate the code, like issuing a variance. And I can't say that I see there is a substantial issue that would cause me to want to issue the variance. So that's where I am right now.
This board's heard a lot of cases over the years of people where we may have had to stretch the definition of hardship that had to be overcome, obviated by a variance. But we've also had a lot of cases where we realized that people want to make, in their estimation, full use of their property and therefore chose to come before the board asking for a variance. I don't think it's unreasonable for a person to want to maximize their profit. I do not think that it is a substantial variance in this case so that they can maximize their profit. We have a substantial difference between staff's opinion on this one and the applicant's opinion on this one, but we can go through every one of those step by step if that would help the board to reach a consensus.
I don't know that it would. I've gone through each one of them myself, and in every case except one, after each party was finished, I agreed in the same way, but for the opposite outcome.
My recommendation is that you go through each one for purposes of the record.
I agree, sir.
Okay.
Okay, let's do that. Looking at the Duncan standards, criterion A, whether the property in question will yield a reasonable return or whether there can be any beneficial use of the property without the variance. Staff has said that it's not. Obviously, you've got a rented single-family structure there. There is a return, but it is, again, a situation that I feel that the property owner is seeking to maximize their profit from their property. But in the strictest sense, can it yield a reasonable return? And I'd have to say, yes, it can. Would you agree with that, Mr. Allen?
Without the variance.
without the
Without a
variance.
variance, because they could build a
Well, they can leave it the
family
way
with
it is,
that. Yeah,
they can
or
put up
yeah.
a new single family.
Yeah.
Okay, so it could yield a reasonable return.
I agree.
Do you agree? Mr. Conrad, do you agree?
Yes.
Thank you, sir. Criterion B, whether the variance is substantial.
That's just,
We are looking at a 6.7% reduction. 4 feet out of 60. That to me is not substantial. Mr. Allison, would you agree?
I agree, especially since they're exceeding the setbacks.
Thank you, sir. Mr. Minier?
yep, I agree.
Thank you. Mr. Conrad?
I disagree with your position. The applicant is asking for a significant, what I deem a significant reduction in size.
Okay. That's fine. That's fine.
Yeah.
Thank you.
So Mike, if I could,
Yes, sir.
where I came down on the other side is the city has reduced the lot widths, which in the past we've looked at areas that didn't have enough width to the lots. And we've said, well, nobody could build anything here if we don't provide a variance. And we didn't really have guidance, but it seems to me, in this case, we have definitive guidance. They've said that we will reduce the size of the lot width, and here are the sizes, and this is what we want.
Okay. But at the same time, we look back at what was done with the upzoning on this, and planning and council reduced the minimum lot width for a 3-family from 90 feet to 60 feet.
Right.
You know, that reduction to me is huge.
Correct.
The reduction here is not. The reduction requested in this variance is
So,
not.
so the question is if we are trying to maintain the spirit of the law, of the ordinances, where do you say it becomes substantial? Is it 50 feet, 52 feet, 54 feet?
And I agree with you there, and I think it needs to be decided on a per-case basis, based on the facts with that application. In this application, 6.7% is not substantial to me. Criterion C, whether the essential character of the neighborhood would be substantially altered, or whether adjoining properties would suffer a substantial detriment as a result of the variance. I think we're looking at a situation here, putting up a new building that is going to improve the property value, has a possibility of improving the property values on adjacent properties, and you're gonna eliminate a 1960s era home to put up a new structure that's gonna substantially improve the neighborhood. Mr. Allison, would you agree?
I agree with what you've said. Also, the setbacks, also the parking. I think it's really important in this part of the city to address the parking, and we've done that.
So you're saying the essential character of the neighborhood would not be substantially altered?
Correct.
Correct, I agree with that.
Thank you. Mr.
Well,
Conrad?
there's another part to that though, but which also has to do with.
Let's go through.
Okay.
Okay, we're looking at the essential character of the neighborhood would substantially be altered, okay? Or whether adjoining properties would suffer a substantial detriment. What we're looking at right now is the altered, and as I said, we're looking at an improvement. If there's an alteration, it's to the positive.
I disagree
Yeah, I do too.
because of
change
the
this?
parking, because of the parking element.
Okay. The parking is at the rear of the lot, which is the preferred area, for parking. You know, I'm not following your logic there.
How do they get to the rear of the lot?
Through the alley. There is no curb cut. The curb cut's being eliminated, so they don't even have to cross a sidewalk. They're going through the alley.
Which is a way, parking off the alley is now a comment, it's in the code to, we approve parking in the alley?
May I respond to that, Mr. Chair?
Yeah.
I don't think it's parking in the alley, it's parking from the alley.
From the alley, sorry,
adjacent,
correct,
uh,
yeah.
For access. So, go ahead.
Yes, so parking is allowed off the alley by right.
Okay.
That is an acceptable place to put parking.
Okay.
I think the third item that we didn't discuss is density.
Well, let's stick with,
No, that's part of this.
okay.
Oh, the essential character of the neighborhood would be substantially altered by the density? Is that what you're suggesting?
That's what I'm suggesting
Yeah.
that we should discuss.
Okay, I see. So so a proposal here is that the essential character of the neighborhood would be substantially altered by the variance because it would increase the density of the neighborhood. And the adjoining.
You're saying it would be altered to the negative.
Well, but I'll ameliorate that by saying that's what council wants. There's a reason this was up zoned. And yes, it does change the neighborhood, but that's the goal,
Okay.
as I understand it.
And I agree.
Okay.
I agree. I don't know whether we're on wood or would not. Are we on wood and not? So we're saying the essential character of the neighborhood would be substantially altered.
No, I'm saying it would not
not.
because that's the
Would not
goal.
be. Well, okay. So two parts. On criterion C, are we gonna say, neighborhood would substantially be altered? Okay.
By the physical presence of the building and by the
Okay.
density of the.
Okay. Again, I'm kind of coming back to, even though it's gonna be altered, it could be altered in the positive, it could be altered in the negative. Okay, are you saying it would be altered in the positive?
In total, yes.
Okay, Ms. Reminier?
I'm saying would not on both of these. That the essential character would not be substantially altered.
Okay, and I agree with that.
And I relate to Kate's
Okay.
comments.
So the essential character of the neighborhood would not be altered. Whether adjoining properties would suffer a substantial detriment as a result of the variance, my take is no.
I
Mr. Allison agrees. Mr. Manier, do you agree?
Yeah.
Mr. Conrad?
No, I do not agree.
Okay, do you want to expand on that, or do you just want me to take your vote as an?
Are we talking about
Whether
criterion C?
criterion C, the second half of it, whether adjoining properties would suffer a substantial detriment as a result of the variance. 3 other board members have said no, it would not suffer.
Then I would agree with
Okay,
all the board members.
okay, 4-0 on criterion C. Criterion D, whether the variance would adversely affect the delivery of governmental services, fire, water, sewage, in this case, fire protection. I think we've addressed that, it's been removed as a consideration. Mr. Allison, would you agree it does not affect delivery of governmental services?
It seems like we should put a requirement that a fence not be built.
We can do that. We're just looking at the decision criteria right
decision
now. That would be
criteria.
part of a motion.
I agree.
Okay. Mr. Manier, do you agree?
Yep.
I agree. Do you agree, Mr. Conrad? With the pedestrian?
Yes, with removal of those poles.
Again, that'll be part of the motion. Okay. Criterion E, whether the property owner purchased the property with knowledge of the zoning restriction. We've had 2 different changes in the zoning code since the owner bought this. Unless he was clairvoyant and I knew Ned Helzer, and I never saw him as clairvoyant, no, I don't think he bought it with a knowledge that the zoning restriction was in place. So, no, he did not buy it with a knowledge.
I think it's irrelevant because the zoning code changed.
My point exactly. So, whether the property owner purchased property with knowledge, no, he did not. Would that be accurate, Mr. Allison?
That's correct.
Okay, Mr. Manier?
Okay, right, I agree.
I agree, Mr. Conrad?
I agree.
You agree. 4-0 on that. Criterion F, whether the property owner's predicament feasibly can be obviated through some method other than a variance. It can.
It can.
It
yes.
can, but he can choose to put up a single family, he can choose to put up a two-family with no variance request. To put up the three-family that he wants to and maximize the return on his investment, no, it cannot be obviated without a variance. Mr. Allison, you agree? I agree. Mr. Manier, do you agree?
Shoot, I don't know what that, I mean, I don't know. I had, it can be obviated through some method other than a variance because he can build a two-family or a one-family.
Well, the question here is, can it be obviated without a variance to build a three-family?
Okay, correct. No, it cannot. Okay.
Okay, and I agree with Mr. Conrad.
I do not believe that it can be. I would vote for a two-family.
I understand that. But in this particular case, to build a three-family on this, is there another means of doing it other than a variance?
No.
Okay, then we're in agreement on that. Criterion G, whether the spirit and intent behind the zoning requirement would be observed and substantial justice done by granting the variance. I think it would be, because the whole purpose of variances is that not every property is going to be an exact match with what your individual codes may be, whether in 1962 when this property was built or today. You'd have to be a little flexible. You'd have to respect property rights. And I think in this particular situation that the intent and spirit behind the zoning code would be observed. Mr. Allison, would you agree?
This is one of the areas where I have trouble, because it seems to me that the city came down and set some fairly nice restrictions on this by lowering the width requirements. And the problem is, was it an arbitrary 60, or was 60, was that a definite cutoff? Was that just an arbitrary number? And it's a 56, it's really 60, that's where I have the trouble with this particular issue.
And without knowing the history behind the zoning change, I don't think we can do more than speculate on that.
Right.
So, but in light of that, would the spirit and intent be upheld? Yes or no?
The part that's being upheld is the desire to increase the density in this particular area.
Okay.
So I think I would be okay with that.
Okay, so we'll take that as a yes.
I
Mr. Mayor?
disagree. I think you said it would not be observed. The spirit and intent behind the zoning requirement would not be observed because the code exists for a reason. And there've been a lot of changes to this land, to this area that has allowed for a lot of changes, and this is not following the code. So that's why I would say not.
Okay. I'm gonna say it is gonna follow the spirit and intent. Mr. Conrad?
I personally believe that it does not follow the spirit or the intent.
Thank you, sir.
Yeah, I think I would have to change my vote as well.
Okay. Okay. Criterion H, any other relevant factor? Do we have any that we want to consider?
The two-family thing is kind of tricky here. I mean, I'm not a developer and I don't own this property, but like the fact that a variance would not be required to build a two-family, to me, is a relevant factor.
Okay.
And I agree with Kate's position completely.
Mr. Allison?
It seems that people are renting property to earn money. It's not out of the goodness of their heart. So So they're going to push the boundaries. And in this particular case, they're pushing the boundaries. And there is an alternative that fits within the code.
Okay. Okay.
Just human nature.
Well, welcome to capitalism. I'm not gonna include, for me, I'm not gonna agree with that in terms of relative factors. You know, we've discussed it repeatedly, and again, we're looking at a lot with variance. But, I appreciate your input on that. Summarize this. Criterion A was a 4-0 vote that it does not support the variance. Criterion B, whether it's substantial, it was a 3-1 vote that it is not substantial. Criterion C, essential character of the neighborhood or detriment to adjoining properties, it would not do that by a 4-0. Criterion D, whether the variance would adversely affect the delivery of governmental services, again, a 4-0 vote that it would not. Criterion E, whether the property owner purchased property with knowledge of the zoning, it was 4-0 vote that he did not, and it would support the variance. Criterion F, whether the property owner's predicament feasibly can be obviated through some method other than a variance. I was specific that this was to build a 3-unit on this property, and it was 4-0, that it could not be. Criterion G, whether the spirit and intent of the zoning code can be observed and substantial justice done by granting the variance, it was a 1-3 vote that it would not support the spirit and intent. Criterion H, we again had repeated comments about the ability to build a 2-family or a single family without variance. Having gone through all of that, board members, is there a motion? And I would remind you that Mr. Conrad has suggested that we have a stipulation or a condition that the rest of the fence is removed if we grant variance.
And no new fence put up on
We
that,
can
on that
include
side.
that, that's fine. Is there a motion?
So if I copied this down right, criterion B, C, D, and E support the variance?
Criterion B, C, D, E, and F support a variance.
Okay. The other ones, okay, so.
And when you're ready to take your vote, just because we don't have a full panel, just to remind you, the motion would require 3 votes and then 3 votes to approve.
Yes, sir.
Which I'm sure you knew.
Been here before, thank you, sir.
Yes, you have. But not everyone may have been.
Yeah, there's that, okay. So, I'll try and phrase a motion to deny the variance. Okay. So, with regard to request for variance BZA 2022-2, a variance to section 1143.07C, minimum lot width for a 3-family dwelling, I make a motion to deny the variance because, now I have to say why?
Yes.
Okay.
Using individual standards.
Because the property in question will yield a reasonable return and can be used beneficially without the variance. The property owner, oops, no wait. I've lost track of my numbers. Okay. The property owner purchased the property with knowledge of the zoning restrictions. That's criterion E. And the property owner's predicament can be obviated through, no, sorry, wrong. I'm sorry, and G, the spirit and intent behind the zoning requirement would not be observed by granting the variance. Is that right?
Yeah.
Okay.
Okay, thank you. Is there a second?
Could you go over it? Could you go over the motion again?
The motion is to deny the variance for lot width based on criterion A, that it can yield a reasonable return.
E, G, and H, and
Cri-
H.
Criterion E, that the property owner purchased the property with knowledge of the zoning. G,
G,
it would not uphold the spirit and intent of the zoning code in criterion G.
and also I want to add criterion H to my motion. Other relevant factors, which is that a two-family property could be built without a variance. So A, E, G, and H. That's my motion to deny the variance.
Is there a second?
Yes.
Mr. Conrad is seconded.
Can I make an amendment?
Certainly.
That a fence not be allowed to be put up on that side of the house.
Since
You
we're,
you have to vote, I think, on the main motion first, because
Okay.
that's a different.
I was gonna say,
That's what I was trying to figure out.
okay.
Yeah.
Okay, there is a motion before the board to deny variance in
Right.
case BZA 2022-02, subject property 314 University, requesting a reduction in lot width under section 1143.07C, using criterion A, E, G, and H. Mr. Moore, if you do a roll call for us, please, and a yes vote denies the variance. It upholds the motion, denies the variance.
All right. I will start with Mr. Conrad,
Yes.
Ms. Ruminier,
Yes.
Mr. Allison,
Yes.
Mr. Schnipper.
No. The motion does carry, the variance is denied. Mr. Allison?
It's moot.
Moot point on the fence then? Okay.
Okay.
That concludes BZA 2022-2. Do we have any new business coming up on the next hearing?
We have, Mr. Chair, we have not received any applications in time for the deadline for the July meeting. But I did want to take a moment to thank you and Mr. Allison for your service to the board on behalf of the Community Development Department. So we thank you very much for your time, your energy, contributed to the board.
I appreciate that. I've got a couple of thoughts I'd like to share before we adjourn. Mr. Connor?
And I want to echo on what Zach has had to say. I've been to some BZA meetings in various areas, and I want to commend you, Mr. Schnipper, for you run excellent meetings, control the proceedings in an appropriate way, and manage the deliberations so that chaos doesn't ensue, which is sometimes difficult when it comes to BZA. So I want to recognize those extraordinary talents that you've demonstrated.
Thank you,
Thank
sir. I
you.
appreciate both your comments. I have a couple of thoughts, and Scott, don't run off. Before we adjourn this evening, I'd like to take a few moments to share a couple of thoughts. This will be my last meeting as a BZA member since I am term limited out. Paul Brady asked me to apply for membership on this board 9 years ago, and I was reluctant to make that application, but Paul convinced me that it really would not take much time since the board only met a couple of times a year. Needless to say, his estimation of the caseload was way off. Still, being on this board has been both gratifying and educational. It's given me a much better insight into the workings of our local government, the city administration, and staff. For anyone contemplating applying to a board, committee, or commission, I would urge you to do so. We're a small community, and we need and value the participation of our fellow Oxonians. Perhaps the biggest takeaway from my tenure on this board is the competency and thoroughness of the city staff, both past and present. Every case the BZA heard was well-researched and well-presented, and that made the BZA's decision-making process that much easier. Thank you for doing so. Now, Zach, I'm gonna bust your chops a little here. Zach's presentations to the board have always been well-researched and well presented. So much so that I've made comments to him about being too thorough. Zach, you do a great job, but you have to make Scott Webb earn his money once in a while. So, if I was asked for a negative about being on BZA, it would be the weakness of our zoning code in terms of enforcement. Without effective enforcement, our code and our decisions become little more than wish list with a hope for voluntary compliance. I would urge Planning Commission and then City Council to address the needed changes and give staff the enforcement tools they so badly need. There'll be 2 new board members at the next hearing, and I wish you well during your tenure. I hope you make good decisions while you're on the board, and I remind you that property rights are highly valued by the courts, but they're not absolute. Be certain to underpin every one of your decisions with using the Duncan standards so that the applicant, and if necessary, the court, understands them. So, 9 years have flown by much faster than I thought it would. Fellow board members, it's been a pleasure to work with you. Is there a motion to adjourn?
So moved.
Thank you, sir. Second?
So, second.
All in favor?
Aye.
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 Meeting's adjourned. Thank you.